This morning, we're taking a closer look at the trial for the death of Manuel Ellis. 3 Tacoma police officers are facing charges in this case. Officers Christopher Burbank and Matthew Collins are charged with second-degree murder and first-degree manslaughter. Officer Timothy Rankin is charged with first-degree manslaughter. We're now more than a month into this trial, and this morning, we're joined by former Pierce County prosecutor and attorney Mark Lindquist. Thanks so much for being here with us.
Thank you.
All right, Mark, let's get right to it. You've been following this case from the beginning. Let's start with the strength of the case as it stands for both sides, both for the prosecution and the defense, and how the passage of I-940, the absence of having to prove malice on behalf of an officer using deadly force, could impact this outcome.
Right, and that's an important point. Prior to I-940, this case simply could not be brought because there's no evidence of malice. And before I-940 was passed, the prosecution would have had to prove malice beyond a reasonable doubt. Now, even under the new law, though, this is a challenging case. All the defense has to do to win is muddy the water. And right now, there's a lot of dirt floating around in the water. I'd say the defense has done their job well, and there's still time to clean it up, though, so we'll see.
All right, and there have been several experts brought on behalf of both the prosecution and the defense. A training sergeant with the Renton Police Department has now testified a few times. He took the stand again this past week, and this time he was talking in his testimony about the level of force used in trying to detain someone, and he said the level of force used in this situation of Mr. Ellis was justified. So I'd like for us to take a listen to some of that testimony regarding an officer's decision making and what they deemed as necessary steps to take next as attempting to restrain Mr. Ellis.
Officer Collins is a fairly, fit guy. I think he weighs over 200 pounds with his gear on. He's probably closer to 220 or 230. And he stated that with very little effort, or seemingly little effort, Mr. Ellis was able to pick him up and kind of drive him back and throw him on the ground. And so now, at that point, that's from the officer's perspective, that's a pretty frightening occurrence. Okay, and we talked about the taser use. I think at that point, you could have started contemplating taser options at that point. So intermediate, higher levels of force, other than just, for example, verbal commands, or, the policy contemplates things like wrist locks or joint leverage. Those are things that are out of play at this point because the level of risk to the officer is higher than that.
All right, so we just heard that part of the testimony. How crucial is a breakdown like that from an expert and giving that analysis to the jury?
Here's the thing to keep in mind about experts. They're highly educated, highly professional, highly paid, and they totally contradict each other. But if one side calls an expert, the other side's going to call an expert to rebut that expert. I think jurors give less weight to experts than lawyers do.
Okay, so perhaps they're maybe giving more consideration to witnesses, you would say?
Yes, witnesses and also the evidence, video evidence, for example, solid evidence they can rely on.
Well, with both of those in mind, jurors have been hearing from some witnesses who were in that area that day. At least one of them took cell phone video of the arrest happening. I want us to take a listen now to 2 witnesses. They were both driving behind one another near where the arrest was happening, and they also told the jury what they saw.
Because what I had seen scared me, and I didn't see any need for it, so I wanted to make sure that whatever happened was on tape.
What did you see Mr. Ellis doing at that time?
Not struggling.
Did you see Mr. Ellis at any time strike back at the officer?
No, I didn't.
All right, so we started to talk about this a little bit, but how much weight could an eyewitness account carry from a civilian when they're talking to a jury like this in a case like this?
Civilian testimony is important, especially if it's perceived as neutral. And sometimes civilians are seen as neutral and sometimes not. I think in this case, the defense did a good job of suggesting that the civilian witnesses had a bias. But even more importantly than that, and you see this in a lot of these cases, everyone has cell phones, but civilians usually don't start shooting the incident until the fight is already on. So rarely will you see the incident in the beginning caught on video. And I think that's an issue in this case, is there's video, which is powerful evidence, but none of the video captures the beginning of the incident.
All right, a lot of things to consider for the jury there. There are various potential outcomes for this case. Could you run through a few of the potential outcomes in the scenarios and how they could actually impact social justice going forward and also local policing policies going forward?
So there are 4 possibilities. Number 1 is all 3 officers could be convicted as charged. Number 2, it could be a split verdict. And by that I mean maybe the 2 officers who are charged with murder are acquitted, but the officer who's charged with manslaughter is convicted. Third possibility, of course, is all 3 officers are acquitted. And the 4th possibility, which I think is likely in a case like this, is a hung jury. They can't agree.
And you think that could be very possible in this case?
I do, because of the nature of the evidence and also because it's a highly politicized issue.
Okay. All right. Mark Lindquist, former Pierce County prosecutor and attorney, thank you so much for your time on this, and we'll continue to track this case.
Thank you.